Good evening. This is John Milburn for Laws 12063 Advanced Statutory Interpretation and Drafting. We're into week 5 of Term 2, 2018. And this week we continue our discussions in relation to the use of language and how that's critically important when it comes to communicating as a lawyer. I do hope that by now all of you have commenced and made some good headway with your assessment piece. It may seem a while off, but the time moves very quickly. So please keep at your work and have something produced and you're underway with that. Now, just on that point, Helen, I understand that you might have a question for us about the way in which we should or you might structure your examination or assessment piece.
Yeah, so should an act or a proposed amendment focus on one of the three issues that were mentioned in week 1? So a mischief to stop something that's already occurring, to manage a risk in the future, or to actually provide a benefit, or are legislators inadvertently doing all three things when they are drafting new legislation or amending legislation?
Sure. No, that's a great question. Thank you, Helen. When you look at any piece of legislation, I guess if you consider what has gone into it that led to its creation, you would normally find that it's created in order to deal with a particular mischief or to create some sort of benefit or to clarify the law in some manner. The short answer to your question is that it can be any one of those, or it can be any two of those, or any three of those. So it need not cover the field. Historically, legislation was created to solve a mischief. So when most of the law was common law based, a couple of 100 years ago, legislation was quite irregular, and it was by far less important than common law. Legislation was generally created purely with the aim of solving a mischief, but that's no longer the case. So when you create your legislation, academic legislation, you can deal with any one of those problems or more, any combination of them. I hope that answers your question, Helen.
Sorry, just one more thing then, John, sorry. So I guess, and that's why this sounds so obvious, but why the whole purposive rule is so central now, because of those three particular issues that could come up. Okay. I'm kind of figuring it out now a little bit.
That's a very good observation. Thank you very much, and I appreciate that observation. Speaking of observations and contributions, I've been very pleased to see the contributions that a number of students have been adding into UCrew. If you're watching this as a recorded session, please take the opportunity to go online, have a look at UCrew, look at some of the excellent contributions from students, and please add your own contribution. So I see we've got Greg here this evening. Thank you, Greg, for joining us once again. And I appreciate your contributions. One that caught my eye this week was your contribution about the use of online tools in proofing in Word documents. So I'm a Microsoft user. I see that you're a Microsoft user, and you've come up with some information through Tech Republic about the way in which the Word program can automatically proofread documents for spelling, grammar, and style errors, and also provide you with an opportunity to set up autocorrect options and to automatically use suggestions for things like identifying gender-specific words. So there are some excellent online tools that are available. Greg, did you want to speak about that in any further depth?
Not any more than what you've discussed, John. It's something, though, that I probably wasn't aware of until you had raised it with us last week, and it was very worthy for me to investigate it. I can use it for work, and now I can use it for the assignment.
Excellent. And I think, was it Siobhan? I think you gave it the thumbs up and said that's been helpful for you as well. So thank you for that contribution. There are a number of online tools that you can use to assist your grammar. One is Grammarly. It's very popular. I don't use it. I used to use it, but if you're looking for options on how to improve your writing, I would certainly recommend that you consider Grammarly. Is anyone familiar with Grammarly or use it? It's an American spelling and grammar style. Yeah, it's you know, it's one of those proofreading tools that will enable you to immediately check something for your work. So I see some people aren't familiar with it. What I'll do is I'll just share the screen, show you that it's Grammarly, and of course it's taking a while to come up, but I will share the screen and just show you this as a brief introduction to Grammarly. So better writing, better grades. Grammarly makes sure everything you type is clear, effective and mistake-free. And you can see there the worked example on screen of how it will immediately make suggestions for you to consider. All right, so that's an excellent resource. While I'm sharing the screen, we'll just have a look at some others. Another contribution was from Jamie, and I'm not sure if Jamie has joined us tonight, but thank you, Jamie, for your contribution in relation to the potential use for @voice aloud reader. And you can see that this is available to you through Google Play. And Jamie says that it's been helpful for her in that very cleverly she has decided to use this app to effectively turn text to speech, and therefore is able to, for example, listen to the study guides while traveling, or by when in some other format. So often when I travel, I will listen to material that assists me in learning, and this is going to be a great app for me to use as well. So @aloud reader, TTS reader, is something that may well be very useful for you and a time saver and help you to learn better. Some other things, generally Tech Republic has some excellent material, as do many others, and that will give you some general information about how to use the software programs that you're using at the moment in a better manner. And finally, I use Drag and Dictate, which I find to be a very useful tool. And of course, there are tools in Microsoft and Google which allow you to translate information. But it can be used for more than just translation. It can be used to actually read the material in much the same way as @voice aloud reader will allow you to do so. So think about those technical ways in which you can improve your writing and cut down on your mistakes in particular. So tonight we're talking about the proper use of language. In order to use language properly, you need to understand it. In the study guide, we have some excellent material in relation to different aspects of grammar, which you may have been familiar with, but it formalises the arrangement and formalises the situation a little more comfortably. So having a look at some aspects of the study guide, firstly, conjunctions, joining words, and they're basically Boolean operators for sentences. So the example that we have in that study guide is taking, if you like, two parts of a sentence and then changing the conjunction, which will dramatically affect the meaning by one simple word. So much of statutory interpretation and good drafting relies on one simple word, and a conjunctional word is something that you must consider as being critical. So the example is, the applicant pays the application fee is one part of the sentence. The other part is, they attend the hearing. So different meaning, the applicant pays the application fee and they attend the meaning of the hearing, or pays the application fee or they attend the hearing, before they attend the hearing, where they attend the hearing, even if they attend the hearing. So there's a whole range of different words that can be used, and by changing the conjunction, you see that the meaning of the sentence, or the way in which the obligation rests upon someone, can change dramatically. When you're involved in arguments about statutory or contractual interpretation, then of course you need to read those words very carefully and be prepared to argue in relation to them. Right, so nouns and pronouns. Here is where you have an opportunity to tighten your writing, but it is very easy by use of pronouns to fall into error. So there are some excellent materials in the study guide. I'd ask you to read this carefully. And the recommendation in the study guide I endorse is this. The problem is that pronouns can be useful if you are absolutely certain what noun they relate to. Here's the example. The contractor planted azaleas in the plaintiff's garden. He considered the soil conditions would suit azaleas best. So when you hear that, the pronoun is he, and to whom does he relate? Is it the contractor or is it the plaintiff? What do you think? Just a straw poll? Do you think it refers to the contractor or to the plaintiff? I'll read it again. The contractor planted azaleas in the plaintiff's garden. He considered the soil conditions would suit azaleas best. Contractor or plaintiff? Contractor, 1 vote. Contractor, contractor, contractor. All right, so I think that's right. But it might have been that the plaintiff specifically asked for the azaleas to be planted because the plaintiff has some specific knowledge of the soil conditions and came to the conclusion that would be the best plant for this. The contractor may have just been a person who has no specific knowledge about gardening. So in that sense, even though we will make an assumption, the assumption may not always be correct. So what do we do about that? Let's look at this option and see if it changes things slightly. The contractor recommended planting azaleas in the plaintiff's garden. He considered the soil conditions would suit azaleas best. Now, having collectively voted for contractors as being the object of the pronoun, I suspect that this variation simply confirms your view in that regard. Because what we've added here is the further comment that the contractor was doing more than simply planting the azaleas. The contractor was recommending planting azaleas in the garden, and then goes on to say the soil conditions would suit the azaleas best. So I think if there was any doubt in the first example, the second example helps to make it clearer, because the contractor was both recommending rather than necessarily just mechanically planting. I'm sure there's a skill in planting, but that wasn't necessarily going to be the case in the first examples. Now, what would happen though if the plaintiff was female? We may have assumed that the plaintiff was male if we had decided that the pronoun did relate to the plaintiff. But of course, if the plaintiff was female, then that changes, that colours the situation as well. The point is that we need to be clear, and our role as professional communicators is to avoid that level of ambiguity. It's up to us to ensure that there is only one realistic manner in which you can interpret the material, which is why, as a general rule, I recommend the use of the active voice and short sentences. The reason for that, it cuts the chance of ambiguity and the risk of error dramatically if you do. Sometimes you need to sacrifice the readability in order to obtain more clarity. In other words, an example of how you might clarify any ambiguity is by saying the contractor planted azaleas in the plaintiff's garden. The contractor considered the soil conditions would suit azaleas best. What you've done is simply remove the pronoun and replaced it with the noun. Not ideal writing, so be creative, but be clear whilst you're creative. Now in the study guide, there's some further comments in relation to phrases, which are of course a group of words within a sentence, and phrases do not include a verb. So they simply provide more information about other elements of the sentence. Sometimes the phrase is added at the start of the sentence, but most times the phrase will be at the end of the sentence. The examples: the applicant contacted the respondent on 6 occasions between December and January. That phrase at the end better describes the level of intensity, the timing of the contact between the applicant and the respondent. The purchaser arranged finance with Heritage Bank. The 3 words at the end are the descriptive phrase that adds more information to the rest of the sentence. Now, clauses are more complicated because they contain verbs, and each clause will somehow affect the rest of the sentence because there's a verb involved. So now we're adding complexity. We may well be writing in a more sophisticated style, but we do need to take more care when we add clauses. And you'll see that there are judicial comments, adverse comments about drafting methodology where clauses become unwieldy. If we are going to add clauses, it may be that the clause is a principal clause, which contains a subject and a verb. In other words, it could be a sentence on its own. Subordinate clauses contain a verb, so they're not phrases, but they can't stand alone in a sentence. Now, clauses can be noun clauses or they can be adjectival clauses, which are descriptive in manner. So the first is a noun clause. Here's an example of a noun clause. It's from the study guide, I think. So they give form to a thing in a sentence. Here's the example. This is how he escaped. Now, you wouldn't necessarily think that the clause how he escaped is somehow related to being a noun, but it is a noun clause because it describes the thing contained within the sentence. The thing is this notion of, or this concept of how he escaped. So that's why it's a noun clause. If it's an adjectival clause or adverbial clause, it's descriptive in nature. So the plaintiff, having experienced this situation previously, changed the locks. So what we have there is an adjectival clause telling us more about the subject or the object. The defendant brandished a knife in a threatening manner, or the applicant filed the documents which complied with the court's requirements. Let's just take an example from the study guides and see how you interpret this. The promisor will supply a flat screen television set, and the promisee will supply a refrigerator in working order. So what do we mean by in working order? Are we talking about the refrigerator being in working order, or is it both? So Tasman says the flat screen may not be in working order. I think you're entitled to that option. Siobhan says the fridge. would need to be in working order. So it's untidy, isn't it? What do we actually mean by that is really the point. So thank you for your contributions there. Now let's talk about the structure of the sentence, and from this you might better understand my recommendation generally to use short sentences. So this sentence has 2 principal clauses and 3 phrases. So let's have a look at it. The supplier agrees to deliver the car. Well, you could just stop there, couldn't you? Because you have a subject, you have a verb, you have an object. It's a principal clause. It could therefore be a standalone sentence. It tells us what the fundamental obligation of the supplier is, and that is to deliver a car. But we go further and we add a phrase, and the phrase is to the purchaser. So that's important because it adds specific detail about the obligation created in the principal clause. In other words, if the supplier had delivered the car to anyone other than the purchaser, the supplier may not have met the obligation. So we're probably comfortable with that. We can add that phrase to the principal clause comfortably. We add a bit more, another phrase. On Thursday the 10th of January. Now that's not a sentence. There's no verb, so therefore it's a phrase. But again, it's important because it provides another specific detail that affects the obligation on the supplier. If the supplier delivers the car on any other date, then arguably the supplier has not met the obligation imposed upon it. So we're still comfortable. We've got a clause, which is a principal clause, and we've got 2 phrases, and they all work pretty comfortably together. The supplier agrees to deliver the car to the purchaser on Thursday the 10th of January. Clause, 2 phrases. Let's go a little further and we'll add a conjunction. We'll add the word and. So now we know that the conjunction is going to join 2 separate clauses and specify some relationship between them. And the second clause is the purchaser agrees to inspect the car. Now that could be a standalone sentence. We've got a subject, we've got a verb, we've got an object. From a legal perspective, it creates a new obligation, this time on the purchaser. So we've now got 2 clauses, 2 phrases, and a conjunction. The supplier agrees to deliver the car to the purchaser on Thursday 10 January and the purchaser agrees to inspect the car. We're fairly comfortable so far. And we'll add another phrase, immediately upon delivery. Like the other phrases, it provides more information. This time it clarifies the obligation in the principal clause that impacts on the buyer. And if the supplier delivers the car and the purchaser waits for a time, maybe a week before inspecting, then the purchaser may not have met its obligation. But by adding more, we might be efficient with the wordage, but we need to be careful that we don't we don't load too much into the sentence to make it ambiguous. All right, so let's talk about simplicity in writing for a moment. You know my general argument, active voice, short sentences. I will make some qualifications to that shortly, but that's generally the way in which I think you should consider your legal writing. Read it carefully, have someone else read it perhaps, and if it doesn't sound quite right, then maybe you need to consider the terminology. Again, from the study guide, imagine that you have a contract with this wording. The contractor will pour the concrete on the 1st of May. Well, it's pretty simple. We know the contractor has to do something, and we know a date. Contrast that with the contractor will have poured the concrete on the 1st of May. Not necessarily the same thing, because the second opens the option for the concrete to pour the concrete on or before that day. It's not entirely clear, but that's what I make of these words. The contractor will have poured the concrete on the 1st of May. From a clarity perspective, does that mean on the 1st of May, or does it give the option of performing it on or before? So why do that when you could make it very clear, is really the point. And what you've seen there is some aspects of tense, past, present, future. And in the study guide, there is a chart which deals with the 12 tenses and the cross-referencing of past, present, future with simple, continuous, perfect, and perfect continuous. So I don't worry, in your assessment pieces, I don't expect you to identify these things particularly. But what we're trying to do is give you some opportunity to consider the way in which you write and the basic rules. Because grammar matters, and it can be the difference between something that is enforceable, something that is not, victory or defeat. So many cases are argued on grammar. So the point is that if you wish to be an effective advocate, an effective lawyer, you do need to have some basic grasp of grammar. So if you don't know what is a noun or a proper noun, a pronoun, an adjective, a verb, an adverb, a preposition, a conjunction, a clause or a phrase, then you need to do some further research to understand those things. Do I take it that we all know that list, or does anyone want me to better explain what we mean by any of those terms? Okay, so Helen said the two main tenses seem to be future simple and future perfect. I think that's probably right. So future simple and future perfect. Examples. Simple future is I will type. Simple perfect, I will have typed. Yep. So that's probably right. No surprises. My preference is always that which is simple. Okay, so I would recommend that you have some basic reference guide to English grammar. So what do we mean by good legal writing, your style? Two things. The first is the basics. You must have the basics correct in terms of grammar, punctuation, spelling. Given that we've identified some online resources that will help you with grammar, punctuation and spelling, it should be easy to satisfy that first requirement of good legal writing, the basics. And bear in mind that someone like me, marking assessment work in legal writing will not take kindly to the basics being incorrect. It's a particular thing that I don't like. Now the second is this. Good legal writing means incorporating your own style. I have suggested short sentences, active voice, but I'm now going to allow you a little more freedom and suggest that good writers in law will often vary the length and will often vary the complexity of the sentence for effect. Sometimes a good writing in law follows different pacing, and sometimes the length of the sentence will affect that. The default position, if in doubt, go with short sentences, but if you're feeling confident and you can do so without creating ambiguity, then guardedly feel free to add something to the length to create some style for yourself. But if you go too far away from the normal situation, it can be distracting, it can be ambiguous, it can be dangerous. And when you write in legal writing, it's quite conventional. I think it's a fair comment that historically lawyers have written far too much in the passive voice, partly because it sounds, I don't know, maybe it sounds more pompous. You see examples of judges writing in cases that are a little old, and they seem to want to write in the passive voice. It just makes it harder to understand. So the key is good communication. You need to follow the good rules of grammar, and you need to avoid ambiguity. Let's take this example. I want you to listen carefully and tell me what you think of this sentence. Mary used Jill's computer and phone, but didn't return it. What's wrong with that sentence? Anything? Mary used Jill's computer and phone, but didn't return it. Yes, Tasman? What do you think about that, Tasman? No, couldn't quite hear you there. I could see you raised your hand, but I couldn't hear you. So looking at some of the chat line, we've got it. Is it the phone or is it the computer? Helen said, that was Andrea. Helen said, didn't return what? And Tasman, sorry, the microphone not working. Didn't say what she didn't return. So yes, so it's just confusing. What are you talking about? What is it in that case? Right, so let's follow it on with this sentence. I'll read the second sentence now. Mary used Jill's computer and phone but didn't return it. She became angry when the power went out. What's wrong with that? She became angry when the power went out. Who became angry? Yes. It could be Mary. It could be Jill. Tasman says, well, there's no relevance. Siobhan says it's disjointed. Andrea, relevance. And Greg said it doesn't seem to relate. So there's a couple of problems there. Number one, who is she and what's this got to do with the story? Now, if you ask the person who's relaying this information, they've got a very clear idea. They say, it's obvious. This is exactly what I'm trying to say. But that's the point. This is what they're trying to say. It's not what they're actually saying. Let's go on to a third sentence. Mary used Jill's computer and phone but didn't return it. She became angry when the power went out. She contacted Jill and said, I know where you live. It's all over the place, isn't it? So now she contacted Jill, probably must mean Mary contacted Jill with a threat. So now we can perhaps assume that the person who was angry was Mary, but why would she be angry when the power went out? Maybe because she couldn't use the computer and the phone. I don't know. So you can see it's all over the place. We've used short sentences, the active voice, but we failed in the clarity aspect of it. So what's the lesson from that simple set of poorly drafted materials? Take time to have someone, well, firstly, maybe pick it up the next day and read it yourself. Don't borrow goods without permission. So firstly, be clear in your speech. Yes. What can we do about it? Number one, maybe you could write it, leave it sit, come and read it the next morning. Often that will be a good guide. Number two, use some of these programs to allow you to have them, for it to read the material, and if you listen to it, odds are you will say, that doesn't make sense, not happy with it, when the machine has read it to you or someone has read it to you. The third option is to have someone else read it and see what they think, if they can understand it. Okay, so thanks for your patience, you're doing well. We'll just move on and do a few other things for this evening. In law, you will often see Latin phrases, sometimes French phrases, and these are often involved in interpretation issues. Sometimes lawyers use Latin and French as a means of creating an air of something being more difficult than it is. So, I mean, why say noli prosequi when you could say offered no evidence, for example? But it sounds much more difficult. So, what you could do is have a chart of common phrases, Latin and French, which are used in law. Ab initio, from the start. Mens rea, the guilty mind. Noli prosequi, the intention not to proceed with a prosecution. Quantum meruit, as much as he or she deserves. In re, in the matter of. In personam, against the person. Res geste, the thing done in the course of the action. So a whole range of things, ultra vires, beyond the power. So you'll see a lot of these. Okay. The Latin phraseology might be sufficient to dissuade even lawyers from dealing with the matter. So, as I said, a lawyer who's not particularly accustomed to criminal law practice might reject a brief on the grounds that the prosecutor desires to proceed by noli prosequi. What a bonus for the lawyer who picks it up in those circumstances. Law of French is less common, but still you'll see it. Estoppel, a blocking. Autrefois acquit, opposing a new prosecution where there's been an acquittal. Voir dire, to speak the truth. Chattel, a thing. So these are all based on French. One that you hopefully won't see anymore is the word querist. It sounds awful, but many barristers would often begin, historically, I haven't seen it for a long time, but barristers would often begin an opinion by making a statement involving the querist. That is the person who asks the question or makes the inquiry. Same, such, and said, which are examples of legalese, are really quite annoying. Talking about, for example, a piece of land and or a person, and then describing them as same. Said, same thing. The said lease, just completely unnecessary words, archaic words that you want to get rid of. Also, other words such as hereinafter, wheresoever, and aforesaid. There's no need for those words. It's really quite pointless. Can you think of any real reason to add those sorts of words? Hereinafter, referred to. We'll just say referred to. Wheresoever, situated. What does that add? Aforesaid.
John,
yeah.
John,
Yes, Greg?
it's Greg speaking. The only reason that I can think of that you may use these particular phrases, the law French or common Latin, would be perhaps in an appeal situation with the Supreme Court, the Court of Appeal, or the High Court, where you're actually lawyer to lawyer, barrister to barrister, High Court judge to High Court judge. I would think in your situation, the QCAT level, where you're dealing with general public and perhaps solicitors whom are accomplished but not necessarily practicing day to day in the law as commonly using that language day to day, you would have to temper how you talk to people and you're looking for clarity. How do you do it?
Yes, look, I agree with you. But I think that relates to all levels. And I think that there's a movement away from the use of those archaic type words, even in the High Court level. So I think that, and part of the reason for that is that there's an acknowledgement that whilst lawyers can talk to each other in code and understand each other, that's doing the general public a disservice, and it's doing the law a disservice, because the aim now increasingly is for the law to be understood by everyone. So when we're drafting legislation, we should write in a way that it makes it more readily understandable by everyone. And likewise in the High Court, whilst there were many cases years ago where people would struggle to understand what the High Court was saying, the idea now, is for that which is said by the High Court to be just as understandable and readable as it would be in any other jurisdiction. So,
thanks, John.
Yeah, no, I take your point, but I think it's got to be something that we all work towards. Siobhan says, seems to be common in wills. That's true. Wills need a lot of smartening up and simplifying, I think, is generally the case. So one of the things that I'm really promoting is this: don't use those sorts of words simply because you feel that you have to, moving into the profession. The words might be used, but it's a dying phenomenon. It's something which is being outdated, and you should be at the forefront of the change in terms of simplicity and better communications. One of the things you can do is remove unnecessarily added words. So you need to be efficient with your writing. So here's some examples. The parties covenant and agree. Does it really add anything to put in covenant and agree? I mean, why not say agree? Does it really add anything? The tenant shall have full use and enjoyment of. Do we need those words and enjoyment? I mean, it's very common. You'll see it in leases. But why? I mean, is that meant to say, by adding those words and enjoyment, that they're not allowed to use it as a workplace because they won't enjoy that? It's hard work. I don't understand those words. This is a certified true copy. Well, if it's a certified copy, doesn't it mean it's certified as being an exact copy? So why do we need the word true? He is exercising his lawful authority. Well, maybe the word lawful adds something, but I think we could do without the word lawful. So this, in response to this form of writing, be careful not to do it, and bear in mind that if you add those extra words, you might actually be leading the reader to ambiguity. As I've said, what do the words full use and enjoyment mean? So if we took out those words and enjoyment, that's probably more clear than by adding them. By adding the words, we're asking ourselves, what does that mean? Why are they put in, as opposed to what? Those sorts of arguments arise. Okay, that's all I want to cover for tonight. Any questions, comments? You're allowed to have contrary views, because a lot of what I'm expressing here are my personal opinions. But I think
John,
Yes, Greg?
I have a question for you. I looked at the synonyms quote in the Week 5 notes from James Champlain Fernald, his 1896 book, and I went to the Gutenberg ebooks library, and it's quite a long way in, so I will upload that to UCrew tomorrow for people, because it's just a magnificent piece of literature, and I read through some of it, and I think people would enjoy it, particularly for their assignment and answering questions 1 and 2 on page 11, just for fun.
Okay, great. Thank you very much. All right. And Tasman says, under current eligibility for rent assessment, full use and enjoyment determines if they are primary residents with borders or shares, and the rates vary. Okay, so full use and enjoyment. I can get the word full. I understand the word use, but it's the 2 words at the end, and enjoyment. That's where I'm not sure if it actually adds anything. Maybe it does. So thank you for that contribution as well. Okay, so lesson for this week is try to remain simple with your terminology, but be prepared to add a little bit of style carefully, but do so without ruining the clarity of your writing. Okay, we won't see you next week. It's university break next week. We'll see you in 2 weeks from tonight. Please keep up the contributions on UCrew. Excellent work, and good on you for sharing information about your draft legislation. So I really appreciate that as well. All the best, and we'll see you in 2 weeks. Bye now.